Hello and welcome. I'm Mike Swanson speaking to you from the studios of Advocate Capital. Today we'll be joined by Jason Lazarus, but first I am the CEO of Advocate Capital. I'm also the author of How David Beats Goliath, the only finance training book ever written for plaintiff lawyers. If you'd like a copy, you can message me and I'd be happy to send you an autographed copy. But today our special guest is Jason Lazarus, and Jason is going to join us now live from Orlando, Florida. There he is. Hi, Jason.
Hey, Mike, how are you?
We're doing great. It's a beautiful day in Nashville. Looks like spring's right around the corner here. We might get a few snowflakes tonight, I think, but then it's going to be in the 60s next week, I think. So that'll be good. How are things in Orlando?
Sunny and warm.
Oh, nice. I need to get back there. I don't think I've ever met somebody with so many letters after your name as you. It's a lot of letters.
I've got a few.
Yeah. So for those of you who don't know Jason has been in the plaintiff industry, plaintiff law firm industry for 20 plus years, and has amassed an incredible amount of knowledge around several important areas for plaintiff lawyers. And so we like to introduce our clients to people like Jason, and he's also a good friend. Before we get started, the disclaimer. So this webinar is for informational purposes only. Do not take any actions or fail to take any actions based upon what you see and hear today, but do feel free to share this content with your professionals, whether accounting or legal. If you've registered, you'll get an email probably by next week with a link to a recording this webinar, so it'd be a convenient, easy way for you to share it with your advisors. However, Jason and I are always happy to answer questions, and we'll have Q&A at the end. We've even had an email ahead of the webinar for a question for later. So that's going to be fun. We want this to be interactive for you. So Advocate Capital is a purveyor of the AvoTrack case expense funding service. We're serving over 500 law firms around the country with that, and growing rapidly. If you'd like to learn more, visit advocatecapital.com. That's all I'll say about Advocate. That's our little commercial. So let's get started with today's content. And most of this has to do with tax issues around various types of damages and strategies for managing your tax liabilities. And the first point I think you want to talk about, Jason, is the taxability of damages.
Yeah, so we're going to start off talking about taxability of damages. Then we'll move on to talk a little bit about tax deferral of attorney fees.
Okay.
And then end with qualified settlement funds, just to give you guys all an overview of where we're headed today.
Okay,
so
great.
The first point and most important point about taxability when it comes to damages for personal injury cases is that if it's a personal physical injury claim, so that there's actually an injury suffered, all the economic and non-economic damages that flow from that are not taxable, and that includes lost wages. The only exception that can arise is if someone's deducted medical expenses for their injuries from their taxes, that can cause the actual portion attributable to that to be taxable. It's rare that people do that, so unlikely to happen.
Okay.
One key point to remember is triggering constructive receipt is bad, and I'm going to talk a little bit about constructive receipt, but just keep that in your back pocket, and we'll talk about that in a moment.
Okay.
Another key point is that purely emotional distress injuries are taxable. So if there's no accompanying physical injury and it's purely emotional, those are taxable damages. And then if you have cases that are employment discrimination type litigation or just employment litigation in general, so wrongful terminations, etc., lost wages are taxable if those types of in those types of lawsuits. So it's different from physical injury cases.
Interesting.
But
Yeah,
two caveats.
Yeah, income is income.
Yeah,
right?
Exactly. Last 2 points, which are important, and it's actually something to keep in mind when we go back to number one, which is generally personal physical injuries are not taxable. Economic and non-economic damages that flow from that are not taxable. However, if there is interest on a settlement, those interest payments or whatever amounts to the interest is taxable. And if punitive damages are claimed, those damages are taxable even if it's from a personal physical injury. So important to keep in mind that interest and punitive damages are taxable.
Interesting. I'm learning stuff already today. This is great. And so some of the lingo here. So SX is settlements, right? Is that what you're referring to there?
Correct.
Got
Yep.
it.
SX is shorthand for settlement. So
Right.
one thing I wanted to just briefly go over was 104A of the Internal Revenue Code, because it is an important provision for personal injury attorneys to have a basic understanding of, which is the provision in the Internal Revenue Code that excludes from gross income personal physical injury recoveries. 104A2 covers personal injuries. 104A1 covers workers' compensation settlements. Both
Okay.
treated the same. So under 104A, an injury victim has two different options in order to receive settlement proceeds. One is the typical, a lump sum. If they take that lump sum, invest it on their own, the gains are taxable. It can impact public assistance eligibility because most of the public assistance programs that are needs-based have asset caps and they can be quite low. So even giving a client as little as $2,000 can disqualify them. The other option, the second option, is the client can agree to receive future periodic payments via a structured settlement annuity. If they enter into that type of arrangement, the investments are never taxed. The investment gains are never taxed because there's an exemption in the Internal Revenue Code specifically for those future periodic payments. And what's important is that periodic payments can be used in conjunction with, say, a special needs trust to keep that client eligible for public assistance. So some key points about taxability when it comes to personal physical injuries under 104A.
Wow, I could see how that could be very impactful to the client.
It's a huge swing for the client when they make these sorts of decisions. So getting some basic financial advice is really important, whether it's about structured settlements or managing the recovery, particularly when there's public benefits involved. That's when it becomes even more critical.
Yeah, fantastic. Okay, you said you wanted to talk more about constructive receipt.
Yeah, I mean, for everyone listening, really the key thing to remember is that when you get money into your trust account, it is constructively received for purposes of the injury victim client, meaning it forecloses some of the options available to them, because constructive receipt, once triggered, means that even though the money is not in your client's hands, it is treated as such for taxation purposes. And really what that ultimately means is that they avoid or they lose the ability to do some planning. So they can no longer enter a structured settlement. In theory, it could impact their public assistance benefits. So you really don't want to trigger constructive receipt unless you know for sure the money is simply going to be distributed to your client. The other key thing about triggering constructive receipt, though, is that if you are considering deferring your fees, you don't want to have the money in your trust account. That for you is actual receipt. It's not constructive receipt. But same idea here is that you really want to make sure you know for certain that there is nothing that's going to be done that would be jeopardized by taking that money into your trust account ultimately. So there's two ways to avoid triggering constructive receipt. One is just have the defendant hold on to the money until you get things figured out. The second is what we're going to end the presentation talking about today, which is setting up a qualified settlement fund. And I'll get into that and explain all of that at the end of today's presentation.
Fantastic. So our viewers really should be thinking about these things well in advance of the defendant making any payments. Sounds like they need to be planning all this well in advance.
Yeah, I mean, really, the key is planning, pre-planning. You know, if it's a case with catastrophic injuries and you know that there's going to be a lot of issues that need to be dealt with, doing a little bit of pre-planning is key to making sure you don't cause a situation where you've triggered constructive receipt.
Yeah, fantastic. So tell us about Rodman's lesson.
Yeah, so the last part of the presentation is about Dennis Rodman, and you know he was famous for his antics off the court, but this case actually stems from something that happened on the court, and it's an interesting case And it's interesting because it's had ramifications outside of the scope of really what these facts were in this case. But what this all deals with is confidentiality provisions and assigning consideration to confidentiality provisions, and the cautionary tale that is the Rodman case. And so the Rodman case involved a $200,000 settlement where Rodman had kicked a cameraman during an NBA game in Minnesota. So fell off the court apparently, in a play, kicked the cameraman. Cameraman brought suit against Dennis Rodman. It was styled as a personal injury case and settlement, but really it was all about ultimately a payoff to keep this cameraman quiet. And in the way the settlement was crafted, basically had a liquidated damages provision that the entire amount of the $200,000 settlement would be liquidated damages if the confidentiality was violated. So ultimately, Amos, who's the cameraman, after the settlement, he says, "Hey, this is all 104A. It's personal physical injuries. I don't have to pay tax on any of it." When he wound up having to litigate this with the Internal Revenue Service, he lost, and 40% of the settlement was deemed taxable and attributable to that confidentiality. And the problem was there was no specification in the settlement agreement as to what portion of the $200,000 related to physical injuries versus what was being paid for confidentiality.
Interesting.
So, and we can go to the next slide. The really critical thing to take away from that is that you never want to assign any consideration to confidentiality. There's no good reason to do it. And on this slide, there's some language that's suggested, and really the crux of it is that if there is a confidentiality provision, it's the agreements, the reciprocal agreements to keep the settlement confidential of the parties that is consideration. There's no financial consideration as it relates to the confidentiality, because if you assign a value, then you're taking damages that really, in the typical personal injury case where confidentiality is requested, you're taking non-taxable damages and turning them into taxable damages by assigning that value. There's no reason to ever do that, but you have to be careful just overall with confidentiality agreements because of this specific issue. So if you can avoid confidentiality, that's great. If you can't, you want to make sure that you use the type of language that's referenced here with that reciprocal promise, because that way you don't run into this issue of, is there some portion of the settlement that's taxable when there really should be $0 taxable?
Right. So that's another excellent point. In fact, one of our viewers emailed a question in advance of the webinar today. So this seems like a good time to ask this, or have you attack this question. How do you recommend handling situations where the release in a personal injury case not only releases the defendants, but also contains non-disclosure agreement, in that the personal injury proceeds are non-taxable, but the payment for the non-disclosure agreement is taxable? And usually there's mention of the release of only a single payment of the agreed settlement amount. So is the language you're saying here will address that?
Yep, that's exactly it. So in that scenario, you want to use some type of language that states this sort of thing. I mean, really the key part is saying that all the money that's being paid are for personal injuries within the meaning of Section 104A2. That's why I referenced 104A, just so everybody had a framework for that and understanding of the importance of it. So it becomes really important that the release state that all damages are being paid for personal physical injuries under 104A2, and that confidentiality is based on the mutual promises and reciprocal promises to keep it confidential versus assigning any type of monetary figure to that. So be careful.
We have another viewer asking, are there materials or will they be available later? So we'll send you a link to this video so you could access the materials that way. Jason, I don't know if you would want to share slides with anybody. Should they just reach out to you if they have a question about some of this?
Yeah, so at the end of the presentation, you guys will have my email address. Happy to send anybody that wants a copy of the slide deck directly via email.
Terrific. Okay, so those will be available. Just reach out to Jason for those. Let's continue and move on to attorney fee deferrals.
Yeah, this is a topic that a lot of lawyers just overlook and maybe have heard about attorney fee deferral options, but never have availed themselves of it. It is pretty surprising to me how few attorneys will actually take advantage of this. And for most attorneys, it really is a great way to deal with the ebbs and flows, the erratic type of income flow that personal injury lawyers face. And that when money comes in that way,
Yeah.
it actually creates tax burdens, and that's where the attorney fee deferral can help alleviate some of those tax burdens by spreading out taxability.
Mm-hmm.
So the timing of income is what you're trying to get a hold of, and that is really something that this can help tame. Since your cash flow is variable year to year, the spikes in income isn't desirable typically, and there are tax planning reasons and cash flow reasons that make it so. So
Mm-hmm.
the fee deferral can smooth out that timing of income and help with taxation.
Makes sense. So this is a legal basis for that?
Yeah, so the most oftentimes when I'm consulted about fee deferral, the question is, can I really do this? And the answer is yes. The underpinnings of fee deferral comes from a 11th Circuit case which basically affirmed a tax court opinion allowing an attorney to invest his fees pre-tax and tax deferred in an attorney fee structure annuity. So in this particular case, the court held that the attorneys, even though they had received a fee, because they had entered into this attorney fee structure arrangement, they did not have current income in that year, and instead they would receive payments in the future via the structured settlement. The key was that the payments under the structured settlement agreement were not funded or secured in the tax court's opinion. And the doctrine of constructive receipt, which I talked about earlier, was not applicable because the attorney had no right to receive their fees before the time the agreement establishing a structured settlement became effective. So basically, the critical timing is that the agreement to defer fees happens when the settlement agreement is effectuated. So meaning before that, there's considered to be no right in the tax services opinion to the actual attorney fee. So that's the beauty of it. So under the child's decision, an attorney, Mike, would you mind going back to that, last slide? Because there's a key point on that slide.
A little click happy. Sorry about that.
Yeah, no worries. There's a PLR that was issued a couple of years ago where the child's case has actually been cited now as precedent by the service. And it was actually cited by the service in a situation where somebody was availing themselves of this same methodology, except in the taxable damages world. So remember, we talked at the outset about certain damages being taxable. So even though you cannot do a tax-free structured settlement, you can, in a taxable damages case, defer taxation of the taxable damages. So an attorney fee structure is basically identical. It's just that you are taking a fee and taking it over time, but the underpinnings are the same. So now the service is relying on Childs to say, hey, the same holds true for taxable damages. So really, at the end of the day, this is not something the service has challenged or taken on since Childs. So it really is the legal basis for continuing to enter into these types of arrangements.
Excellent. Let's talk more about reasons someone would want to defer.
So I've already said the first one, pre-tax and tax deferred, there's a huge advantage to being able to invest on that basis. So for the attorney, in terms of the investment options, there's a lot of different ways to do it, from fixed investments to variable investments, mutual funds, ETFs, stocks and bonds. There is no limit on contributions and no penalties on withdrawals, which is a beautiful thing. For the attorney,
Wow.
it gives them that control over timing of income and taxation. And it can be used to supplement existing things that you're already doing as part of your retirement plan.
Yeah, that's fantastic. And I didn't really think about that, but with an IRA or 401k, if you have some of that going, this compares quite favorably, right? Because like you put in there, there's no limit on what you can contribute essentially or take out, which is very different from an IRA or a 401k.
And so there's a lot of ways that obviously you can put this to work for your firm, but specifically it helps you because you can customize your cash flow management. Less is going to be lost to taxes. Application of the alternative minimum tax can potentially be avoided.
Yep.
If you don't want any more taxable income in a specific year, it allows you to control that by deciding to make the deferral. Most states have some type of enhanced legal process protection if it's in an annuity. For example, in my home state, we have a Florida statute, which is the one that's cited on that slide, that specifically exempts annuities from legal process, and many states have that. There also are some mechanisms with some of the plans that I'm going to talk about that allow you to basically set this up for T associates, which basically sort of ties them to your firm because of the future payments they would receive from a non-qualified deferred comp arrangement. So definitely some great reasons to use these types of mechanisms.
Wow. Okay. Should we move on?
Yeah, I mean, the things I mentioned at the bottom of the slide are just basic things. I mean, really, at the end of the day, this can be set up to have immediate payment streams, deferred payment streams. It can be set up. I've had lawyer clients I've worked with who've set up future periodic payments for key times in their kids' lives, so that they get lump sum payments or periodic payments to help offset college. I mean, there's a lot of different ways that this can be used. It really ultimately boils down to the lawyer's desires and needs, and that's really through exploration and looking at your future plans.
Yeah, we share quite a few clients, and I always like seeing their financials when they've done some of this fee structuring. I just think it makes life a lot easier. It's more efficient. You end up paying less tax in the long run, and I think it removes a certain level of stress from managing a PI firm or contingent fee law firm, because you don't know what's coming, in 2 years and 5 years and 10 years. And so being able to lock in some future payments takes some of that pressure off. And I know some clients who've been doing this systematically for a long time, and they've set up a beautiful retirement for themselves.
Yeah, I'm going to talk about it a little bit later, but I mean, that you hit on a key point is, as part of an overall plan, this just makes a lot of sense. And that's where I think oftentimes it's overlooked, because lawyers may think of it as an all or nothing proposition. And again, I'll talk about this momentarily, but it's not that. You can take portions of your fee. It doesn't have to be an entire fee, and enter into some of these arrangements. So critical to really make it part of an overall broader plan, which, if it's comprehensive, is really great for your own personal balance sheet at the end of the day.
Yep. Absolutely. Great. Okay, let's talk about.
So, one thing on the previous slide, I mean, I think it's key to remember that it's completely different from a qualified plan. There's no max or min contributions, no limits on when or how to take distributions. You can take it prior to 59.5. Employees are not covered by this and doesn't apply. There's no ERISA compliance. So it's basically an unlimited type of plan that you can avail yourself of compared to the qualified plan. So max out your qualified plan and then do this as an adjunct to the qualified plan, because you've got no limits.
Fantastic. Yeah. So if you're doing a SEP IRA or something, you have to include employees, right? But not on this. So, wow, I'm learning a lot today. This is good. Good stuff. All right. We want to talk about annuity-based attorney fee structure?
Well, so this is kind of getting into the different solutions. So we'll get into a little bit of the nitty-gritty about the different ways that you can achieve tax deferral. There's two primary ways. One is with attorney fee structures, and there's 3 different solutions that fall under that category, and then deferred compensation plans. So there's fixed attorney fee annuities, there's equity indexed annuities, there's non-qualified attorney fee structures, and then deferred compensation plans for attorneys. And we're going to get into kind of a little more detail about each of those now.
Okay.
So for attorney fee structures, the annuities that are used are identical to the ones that are used for structured settlements for personal injury victims. And so if you've seen the different types of plans that have been put into place for clients, all those types of options are the same options that are available to trial lawyers when they set up an annuity.
Mm-hmm.
It's done exactly the same way as it is for the injury victim, which means it's done at the time of settlement. It's part of the settlement documents. So by doing this, the plaintiff attorney avoids the constructive receipt and defers the fees and associated taxes by utilizing that attorney fee structure annuity. And we've talked about this. The payouts, once the fee structure begins to pay out, are taxable in the year received. And then the attorney can structure all or part of the fee. And there are no typical minimums. The only minimums are there are some life companies that will set a minimum of, say, a $10,000 investment in order to set up an attorney fee structure annuity.
Okay.
Other than that, there really are no limits.
That's very low.
Yeah. So an attorney can take small chunks of fees and defer it out over time because there's just no limit on that.
Mm-hmm. Okay.
So two different types of attorney fee structures. There's fixed, and the fixed means that the annuity payments will not vary. They're not market-based returns.
Mm-hmm.
It's going to be very similar to a bond type of investment in terms of the returns. So with that comes predictability. There's no investment expense with this type of solution, but it is a conservative type of return, but you don't have market risk. So there's the upside of that. So the alternative to the fixed is an equity indexed attorney fee structure. So really very similar to the fixed, except that the returns are tied to the performance of the S&P 500 over the preceding 12-month period. The beauty of it, though, is that there are no decreases in the payments if the S&P 500 flatlines or goes negative. So annually, the payments just ratchet. So they continue to only go up. If they don't go up, it stays the same as where it was. So it's a nice product. The downside to it is there is a cap. So they cap it at a maximum positive return of 5%. They've been talking about ratcheting up that to 7%, but they've not done so yet. I think 7% would be a great improvement, but the 5% is still very nice return considering you're taking no downside risk. And really the critical thing to understand about these solutions is that, and you should talk to your investment advisor about it, but most people should have a good chunk of their investments for retirement in some type of fixed income vehicle because it doesn't have the variability. So having these types of solutions as your fixed income because they are pre-tax and tax deferred is a beautiful thing for lawyers.
Yeah, I tell you what, compared to a bond fund, that 5% is not a bad max, especially if there's no downside risk on the principal. Because if you're watching the S&P the past couple of days, if you're a shareholder in a public company, it's a little bit scary. So that's fascinating.
Yeah, it's been taking a bloodbath the past couple of days. So really, the only point of this slide is that when you are comparing a attorney fee structure annuity, you should really compare it to a bond investment. And because the bond investment is going to be after tax, when you compare everything, you are going to be to the good in most scenarios by a substantial amount of money. And this actually doesn't even take into account a state income tax rate because in Florida we don't have that, but many states do. And that even makes it more desirable to enter into these types of transactions. And really the critical thing is because you're investing more money since it's pre-tax and tax deferred, it's generally going to be much more positive for the attorney to enter into this type of an arrangement versus doing a comparable investment in a bond portfolio after taxes.
Got it. Got it. Let me pause for just a moment. We have a few folks saying that they're having some trouble with the audio and or video. So we apologize for that. The internet is sometimes unpredictable in terms of bandwidth and this kind of thing. But rest assured, we are recording this here in Nashville. And when you get a link to the recording, our experience is it'll be full audio and full video as well. So apologies if you're having any trouble. It's really only a couple of people. Just want to mention that. Please continue, Jason.
We can move to the next slide.
Sure.
So I talked a little bit about the equity indexed attorney fee structure a second ago. Really all this illustrates is how the performance just continues to step up and there is protection against downside risk. So as Mike said, given what's going on in the stock market, these types of products are a great product if you want a little bit more upside but don't want to have the downside risk. So comparable to the fixed investment vehicles, but gives you a little bit more upside potential because you've got that ability to go up to that 5% cap on the performance of the S&P.
Great.
So, okay, I've just talked about the attorney fee structure annuities. So another type of attorney fee structure is what we call the non-qualified fee structure. One such product is called a fee structure plus. What this is, it's what's called an offshore assignment. So in order to achieve the tax deferral, you have to make an offshore assignment. So part of the underpinnings of an attorney fee structure is there's an assignment. The assignment is done to a assignment corporation that's part of the life insurance company when an annuity is done. This type of product, because it doesn't fit within that exact model, it has to be done offshore, and that's because of tax treaties that allow for this to be done. So this is a offshore assignment in Barbados that allows for that same tax treatment under Childs. The nice part about this product is that it gives you the same type of tax deferral, but the potential of market-based returns. So you get a 1099, like I talked about, when distributions are made, it's taxed as ordinary income. But with this, you can use your own financial advisor, or there are model portfolios that are available through Evolve Bank and Trust that can be used. So the funds are ultimately invested based on the lawyer's selected risk return profile. And you can use stocks, mutual funds, ETFs, fixed income, alternative investments, basically whatever you want. So this is just an alternative, allows more control over the investment. So if you want a fee structure but don't want an annuity, this is the type of product that can be utilized.
Wow. I'm glad there are smart people like you to know about all this stuff. I got to tell you, my head's spinning a little bit right now, but this is great stuff. I'm so glad this is available to our clients, so many of these great techniques, and I sure hope they'll make use of some of these. This is fantastic.
It does get a little complicated, but that's where advisors like Synergy can come in and go through all these different options and help compare and contrast. So, and that's what I'm trying to do here. So, you start off with attorney fee structure annuities. Then we talked about this offshore assignment, the non-qualified attorney fee structure, and now deferred comp. So deferred comp is different in that it's not an annuity-based type of solution. It's not, there's no offshore assignment, but it allows you control over the investments and also extra control over timing of income. So what this is a non-qualified deferred compensation arrangement. These have been used for years by Fortune 500 executives who defer their compensation through these types of plans. It gives you the ability to control the timing of income and the resulting taxation. So that gives you more liquidity and a better plan for your financial future. So these types of arrangements are really powerful. So instead of doing fee deferral that's based on annuity type of return, you are able to decide how to invest the monies, and you can customize that however you like, just like you would do in any other retirement plan. So the reasons why you do this type of plan is really, it's all the same reasons. And while there is beauty in this deferred compensation plan, there are virtues of all these products, which is ultimately what I'll talk about at the end here is how to use these sort of all in concert, because really there's a lot of different ways that you can put these to work for yourselves. But really, it does all the same things I've already talked about: reducing tax burden, enhancing wealth accumulation. This in particular has the feature that can help you retain key members of the firm. So how this works really is it's a bucket mechanism. So say that you want to take $1 million in contingent legal fees and defer that. What you would do is you take the $1 million, you split it up into 20 quarterly payment buckets, so over 5 years, and you have those payment buckets paid to you. 13 months in advance of any payment bucket, you can elect to either receive that payment or further defer it. That gives you that more control over timing of income.
Yeah.
So
like you're having a good year,
that's
okay,
a unique feature.
Push out a little further.
Yeah, now you cannot do this with any other product. This is the only product that you can do that sort of thing with. And there's some tax underpinnings that allow for this. But this graphically shows you what it looks like. So say you had made the decision in 2018 to defer, and then in 2019 you make the decision whether to defer or not. If you say defer that first payment in 2020, you see it goes to the end of the line, right? It goes to the back of that line. So that payment is now deferred out for the remainder of the term. So that is really the beauty of doing something like this, is that laddering effect and being able to have those payments deferred at the election.
Nice. So there is, before you start with this example, I think you're going to talk about an existing client you actually had. There's another question that came up, Jason. And here is what one of our viewers is asking. Do municipalities who are defendant payors in a PI and civil rights case ever care from their own tax perspective about the plaintiff's allocation to taxable versus non-taxable in the settlement agreement? Have you had any experience with that?
Generally, they don't. I have been involved in those types of settlements. You have to be careful, and really what you want to do, and this is not what I do day in, day out, but there are lawyers who are experts on taxation of damages. Mike and I actually are working with one of the most renowned experts in the country, Robert Wood, who is a tax attorney who specializes in qualified settlement funds, which is something that Mike and I are working on with Robert. But taxation of damages is another area. And you really want to have somebody like that weigh in if you're going to do anything that's out of the norm in terms of allocating between damages, because that you have to make sure you get right, because otherwise you wind up in tax court.
Makes sense. And no one wants to be there.
No.
Great. So I think you had an example you want to talk about.
Yeah, so I mean, really what this shows graphically is what it looks like to normalize income. So, what this shows is a spike in income. And obviously, income is variable to everybody, and this is just a way to graphically show if you had a year in which you had a quote larger year with a $1 million fee, and you elect to fee defer it, that mauve part of the spike gets spread out over time. So, when you look at the amount that you are receiving that year, it looks like you're receiving like just the rest of the smaller years, but that money then is deferred out over time, and you have more to invest because you're not having to pay tax except on any amounts that you recognize. So in this example, it's $200,000 in income, deferring the balance of it. So that allows you to invest that $800,000 versus $500,000 in a situation where you're not using a fee deferral mechanism.
Yeah.
So this is hard to see, and really it's unimportant to read. What this is, though, is a spreadsheet we created for a client that I spent about 15 years working with to develop a plan to structure attorney fees systematically for them. what they did is they decided to take 10, 15, 25 grand, 50 grand, 100 grand at a time out of their attorney fees and defer it using attorney fee structures. So what they did by doing this is they spread out the premium amongst all these different life insurance companies, had different payment schedules based upon their specific needs, when they wanted to retire, when they wanted extra income, when they wanted to have money available for special events that they knew in their lives. So Mike, if you can go to the next slide, I think it shows, so this is showing the different payments that are coming in on a monthly basis in 2019. So in 2019, they had about 100 grand coming in just off of random amounts of money that they had simply put away using these mechanisms.
So this can be done cost effectively, even though there's small individual amounts. This can still be done. You don't have to have $1 million settlement you're looking at.
$1 million fee, yeah. And the beautiful part is there's no ongoing expense with this. There's no expense in setting up an attorney fee structure. So, this shows the different markets and how much money is coming in from these different markets. So they had all these different checks coming from different life insurance companies. One, it was to make sure that if there was a default, which is highly unlikely with any of these insurance companies, but if there was, they had it spread out amongst all these different companies. So if you have Berkshire Hathaway and MetLife and New York Life and Pacific Life and Prudential, if they all go out of business, well, our economy has collapsed at that point anyway. So basically,
bigger problems.
Yeah, they've systematically taken money and put it away over time in small chunks, which is a perfectly cogent strategy for planning. And what they ultimately did was they sort of got to a point where they had maximized the amount they wanted to put into attorney fee structure annuities, and then they started setting up the non-qualified deferred comp arrangement that I had mentioned. So they took multiple different product solutions to ultimately achieve what they wanted, which was, at some point not to have to work as hard. And, since I'm on Facebook friends with the attorney, the managing partner of this firm, I know he's told me, he's like, my passion is flying. And, now I get to do that more frequently because I have all this recurring income that's coming in that every year starts the year off and I don't have to work as hard. I still want to work, but I don't have to work quite as hard.
Well, a lot of what we're talking about has to do with retirement planning, but really what we have seen with clients, if you can do this earlier in your career and even out those payments coming into the law firm, you're actually going to be in a better position to serve your clients, because it's very difficult, but it's very much a reality that in plaintiff law firms all around the country, there are conversations such as payrolls next week, we need to settle something, right, which should never happen, or we have this case of a lifetime, let's settle these cases quickly to get that. So if you can smooth out your cash flow, you're going to be sure able to retire eventually more easily, but you're going to be able to run your practice better and invest heavily in your cases when it's needed. So hey, we have another question. This is Charles, and Charles is asking, shouldn't language be included in the contingency fee agreement permitting the attorney to defer part or all of his fee if the attorney's firm has an employment agreement with their, well, it might be two questions. Why don't you, yeah, let's take that. He has two questions. The first one is, should language be included in the contingency fee agreement permitting the attorney to defer part or all of his fee?
It's not required, but it's a good idea. So because the tax service views that, as I said, that really the opportunity to defer is not crystallized until the settlement agreement is finalized, because they view it that way, there really is no reason that you have to have it in there. Although for the non-qualified deferred comp arrangements, there is recommended language. So, in the end, it is a good idea to have it in the contingency fee agreement so that there is no question about that ability.
And I would imagine
there is no requirement for that.
So if someone wanted, though, to get some sample fee agreement language, would you be able to help them with that?
Yeah, absolutely.
Okay, so Charles, send an email to Jason after this. Question number two, if an attorney's firm has an employment agreement with their attorneys, should the employment agreement be edited to allow the attorney to defer part or all of the fees?
So, it gets into a bit of the weeds with that question. And really what I tell clients is they should really talk to their tax advisor
Yeah.
and their tax lawyer, maybe employment lawyer. When you get into those sorts
Yeah.
of minutia, it really is best to bring in experts and analyze, because it depends on how the firm is set up. Corporate entities and all those different issues need to be analyzed to make sure that you've got everything set up the right way ultimately. It's never a problem for a lawyer to defer his or her own fees. It gets a little more complicated when you get into other employees of the firm. But I can tell you this example, this particular firm, the three managing partners, basically they worked out an arrangement whereby each case, each lawyer had a portion of the fee that they claimed as part of their attorney fees, and then they all did this type of planning that you see on this spreadsheet. This is just one of the attorneys, but they all did this. They took pieces of each settlement and deferred it out based on an agreement they had all entered into in conjunction with consulting with their CPA.
Right. Great. Okay. Anything else about that, or should we move on to QSFs?
No, I think that gives you a firm basics of the attorney fee deferral. It does get quite complicated, but like Mike said, there's a lot of great reasons to do it. And the idea of evening out your cash flow is another great point that Mike brought up, because that really is another key reason to do that type of planning, not just the retirement side.
Yeah, great. Okay, QSFs. Most people think of those as just having to do with mass torts mandated by the defense side, but we're talking about something a little different here, right?
Yeah, the QSF is not limited to the mass tort world, and most trial lawyers have not ever been involved with the establishment of the QSF. So I wanted to talk about it because it really is a unique tool, and there are opportunities to utilize it that will benefit both the attorney and the end injury victim. But really all the QSF is a trust that's created pursuant to the Treasury regulations found at 468B-1. And it's a holding tank for a settlement, and it allows you to enter into what is essentially a cash settlement with the defendant. They just agree to make a payment into the qualified settlement fund. There is no requirement that it's got to be a mass tort. It can be a single plaintiff. The provisions in 468B say that it can be set up to resolve one or more claims. So the only limitation on the single plaintiff side is that some life insurance companies will not enter into a structured settlement transaction if it is a single claimant 468B, and that's just for the injury victim. And the reason for that is because some of the insurers have been difficult. And when I say that, AIG is one in particular. I know for most trial lawyers, they don't love dealing with AIG. AIG takes the position that there's a problem in that scenario, and really they've lobbied the life insurance companies not to accept those types of structured settlements, really on behalf of the defense structured settlement industry, which is unfortunate, because this is a tool that makes sense because it allows you to settle that case just like a cash settlement, but it doesn't trigger constructive receipt. So the money sits in the holding tank. Decisions whether a structured settlement is entered into, if there's Medicaid, whether a special needs trust is put into place, if it's Medicare, does an MSA need to be established?
Right.
You can make all those, you can deal with all those things, liens, complicated lien issues, all those things. You have the time to plan, and you don't have to deal with triggering that constructive receipt. The only drawback is that it does require court approval, and there's some additional costs and time to setting one of these up, but those are simply outweighed by the benefits of establishing one of these. So under the law, there's only 3 requirements to establish a qualified settlement fund. It's got to be established pursuant to an order of a court of law. It doesn't have to be the court that's got even jurisdiction over the case. It's any court can establish those. And It's got to be established to satisfy. Yeah. So
Oh,
You
wow.
can go anywhere. You can forum shop this. Typically, it's not. It's easier just to go to the trial court if the case is already filed. But I've actually had cases where, through my law practice, I've established one of these by going to a local court, even though the case was out of state. The court established the QSF, and we got it funded. So it doesn't have to be established by that court that's got jurisdiction over the matter.
Interesting.
It's got to be established to resolve or satisfy one or more claims asserting liability arising out of a tort. That's typically what we're dealing with in this context.
Yeah.
And then it's got to be a trust under applicable state law. So quite simple.
Yeah.
So in terms of how it works when you've got a qualified settlement fund, basically you would do a standard cash release with the release saying that the consideration would for the release would be a payment made payable to the qualified settlement fund. You petition the court to establish and get an order creating the QSF. The funds stay in the QSF without triggering constructive receipt until all the allocation decisions are made. If there's multiple claimants, liens taken care of, SNT or MSA issues dealt with, if there's going to be structured settlements for either the injury victim or for the attorney fees, those plans are decided upon, and then the QSF automatically terminates when all the funds have been dispersed. So there's certain cases where it really makes sense to establish a QSF. One where there's multiple claimants and allocation issues between. Another one that arises sometimes is where there's multiple layers of coverage and you want to aggregate settlement proceeds. So say there's a scenario with 3 different layers of coverage. You settle with the smallest layer of coverage first. It's $100,000, but you know there's 2 million and 5 million out there, and this is a catastrophic case, and you think that there's going to be a lot more money. Well, you don't want to make decisions based on a $100,000 recovery. You want to put it all together and then make the final decision once everything's been resolved. This allows you to do that. If there's complex lien resolution issues, which is something Synergy deals with daily, you know, if you're dealing with a large ERISA lien that you're trying to get waived or compromised, or Medicare conditional payments that need to be resolved, or Medicare Advantage plans, FEBA, military, whatever type of liens. Public benefit planning issues, those are the types of things that typically you really are going to want to make sure that you try and find the right tool to deal with it, which is the QSF.
Great. So
but the last point is an important one. So if structured settlements are contemplated either for you or for the client, that's the beauty of the QSF. It allows for that to be done with no issues. The defendant doesn't have to be involved. The QSF steps into the shoes of the defendant.
Would someone want to always just have fees go to the QSF? Because then that gives them time, they can think about it. I mean, do people do that? Just set up a QSF and use it all the time? Or you have to have a separate QSF for each case, I imagine?
You set them up separately for each case. You know, the scenario where we've had some clients use the QSF for fees is where it was a multiple claimant situation, actually in a first party case where basically they wanted to aggregate all of the client's monies so that the attorney fees could actually be deferred. And it's a perfectly good use of the QSF, but each settlement had to have its own QSF. So typically it's not recommended as just a simple way to deal with attorney fees. Really, that's best dealt with by making the decisions prior to the settlement being finalized versus using a QSF. But there are situations where it does make sense to use the QSF for attorney fees, particularly if you've got a defendant who doesn't want to be involved in the attorney fee deferral. Sometimes we get that, like some defendants can be difficult. AIG is one of those that sometimes can be difficult. So, you know, that's where the QSF potentially can step in and avoid those issues.
Right, great. So we're coming up on our hour. This has been very informative. Do you want to just mention the pool global QSF that we're working on?
Yeah, so this last point, and quickly, this is sort of groundbreaking and unique, and we're pioneering it together. And so a pooled QSF is a different way of approaching qualified settlement funds. And why it's unique is that instead of having to create a really complicated set of documents each time you want to set up a QSF, which involves creating a new trust, there's a master trust that people join. And this is patterned after a very well renowned concept that's used in special needs trusts, where you have a master trust that people join. So in this solution, it's a very low cost method of setting up a QSF. There's a 0.001 fee that's charged against the opening trust balance. Our foundation for special needs is the trustee. Pinnacle Bank is the custodian of the assets. And it's set up for all the reasons I've already talked about, but it's a nice solution. It's way easier to use and much more simplistic to set up quickly and low cost at the end of the day.
Right, and so that would make more sense if you're doing some of the smaller deferrals as well, perhaps. So great. Wow, this has been so informative. I've learned a lot today. I knew I would. Every time we talk, I learn something from you, Jason. I appreciate that. I look forward to seeing you here in Nashville next month when you come out. So let's open up to questions. If people have other questions, go ahead and type them either in the chat box or the question box. We will keep your identity anonymous. If we do that, we won't give your last name, just the first one. So let's give folks a chance to type questions if they have them. I have a question. How long can a fee stay in a QSF before it has to be, before you have to have constructive receipt take place?
So there's no definitive answer to that question. The tax service has never been asked to opine on that. I would be concerned about keeping it in there beyond a taxable year, because it's really not meant to be used in that way. Now it can be, and frequently in mass torts it is used spanning multiple tax years, but each tax year the QSF has to report, and that can trigger some scrutiny. So I know that there are some out there that are using QSFs as a tax deferral mechanism. I think that exposes the lawyer to a huge amount of risk, because there's absolutely no legal basis for doing that. And I don't know that you'd even get protection from penalties and interest with an opinion letter on that, because there's just really no basis for that.
Great. Great. Well, it looks like our viewers asked their questions that they were going to ask during the presentation. That's always a good thing. So we're going to wrap up shortly here. This is Jason's contact information. If you have, or did I miss a question, gang? I'm getting a signal. Okay. There is a question. Will this webinar recording be available to show another attorney? Absolutely. So if you've registered, you will get an email with a link to the video of this. It'll be hosted on Vimeo, so you can share this with your tax and legal advisors and other attorneys. Absolutely. And if you want to contact Jason directly, he can get you a copy of the slide deck that we used today. If that would be helpful. Also, he has offered very kindly to help you with some of the fee agreement language that might appear here. Here is Jason's information. Give him a call, shoot him an email. Synergy is a fantastic company. Jason and I share a lot of clients together. I've heard nothing but good things from them about that. They do a lot more than just what we talked about today. I recommend you take a look at what they can do to help you get even better results for your clients. So here's their contact information. Oh, we have another question. Good, that's good. I'm closing too early. Let's get to this. Do you all work with tax advisors? I'm not. So I guess they're asking, I'm not sure if they're asking, do you have a tax advisor in particular you work with, Jason?
Well, we do, and then we will frequently work with a law firm or lawyers, tax advisors, to give them the information that will typically make them feel comfortable with these types of arrangements, because as I said, most oftentimes those folks have never come across this before. So just giving them a little bit of foundational information typically helps them understand how this all works. Great.
Okay, sorry for trying to wrap too early. If you have other questions, just shoot Jason or myself an email. We're happy to speak with you. And I'm sure even hop on a call if that would be helpful to you, especially if you're one of Jason or Advocate Capital's clients. So I think that's about it for our presentation. This has been brought to you by advocatecapital.com. For more information about how we can help your practice, you can visit our website. If you'd like to see other videos of other webinars we've done, visit our video page and click on the webinars button. It'll scroll you down to our webinar section. We do these monthly. Next month we have as a special guest Philip Miller here in Nashville. He'll be right here in the studio with me, and we're going to be talking, I think, about maximizing returns on your cases, but we'll get more to you. So if you watch for that email, it'll have a link to the video. It'll also have a link so you can sign up for next month's webinar with Philip, and we look forward to seeing you on future webinars. Jason, thanks so much for being here.
Thanks for having me, Mike.
Absolutely. Take care.